I was sitting on my back porch when I first noticed the surveying crew tramping around the lake, and something in my gut told me this was going to be trouble. The lake had been in my family for 3 generations. My grandfather bought the entire 60-acre property back in 1952, including the 20-acre private lake that sat right in the middle of it. When the housing development went up on the adjacent land in the 90s, he'd sold off some acreage for a decent profit, but he'd been smart about it. He kept the lake, every single inch of it, along with a 100-foot buffer zone around the entire shoreline. I'd inherited the property when he passed in 2019, and I've been living in the original farmhouse ever since, working remotely as a software consultant and enjoying the peace and quiet of rural Wisconsin. The Pinewood Estates development had always been somewhat of an eyesore to me, with its cookie-cutter houses and manicured lawns, but the residents generally kept to themselves. Sure, occasionally someone would wander down to fish, and I usually didn't mind as long as they asked first and didn't leave trash everywhere. But this surveying crew was different. They were official, with equipment and clipboards, and they were marking spots all around the shoreline on what I knew damn well was my property. I walked down there that first afternoon, my boots squelching in the muddy ground near the water's edge. The crew chief, a middle-aged guy with a sunburned nose, looked up from his theodolite. "Can I help you?" I asked, trying to keep my tone neutral. "Just doing a survey for the HOA," he said, wiping sweat from his forehead. "They're planning some improvements." "What kind of improvements?" "Dock installations. Going to be putting in 40 units, really nice ones. High-end stuff." I felt my jaw tighten. "On whose authority?" He shrugged and pulled out a work order. "Pinewood Estates HOA. Says here they own the lake access rights." "That's interesting," I said slowly, "because I own this lake, all of it." The guy looked uncomfortable. "Look, man, I just do the surveying. You'll have to take it up with the HOA board. My work order is legitimate as far as I know." I took pictures of everything that day, the markers, the survey equipment, the work order he'd shown me. Then I went home and pulled out my property deed, the original survey from 1952, and every single document related to the land sale in the 90s. I spent hours that night reading through every page, and my suspicions were confirmed. There was absolutely no mention of lake access rights being transferred to the development. The only thing they had was a right-of-way easement for a single access road and utility lines. The next morning, I drove into town and met with Richard Pemberton, my attorney. Richard had handled my grandfather's estate and knew the property history well. "They can't do that," he said immediately after I explained the situation. "Your grandfather was very specific about retaining all water rights." "That's what I thought, but they've already started surveying. I'm thinking they're going to push ahead regardless." Richard leaned back in his chair, tapping his pen against his desk. "Here's what I recommend. We could file an immediate injunction, stop them in their tracks, or—" He paused, a thoughtful look crossing his face. "Or we let them build. If they construct permanent structures on your property without permission, that's trespassing, conversion of property, and potentially criminal. The damages would be substantial. Plus, if they're doing this knowingly, after you've informed them of your ownership, it strengthens your case considerably." I thought about it. The vindictive part of me liked the idea of letting them dig their own grave, so to speak. "How much would we be talking about in damages? 40 luxury docks? High-end construction? You could be looking at $500,000 in improvements, maybe more, plus legal fees, punitive damages if we can prove willful misconduct, loss of use of your property. We could easily be talking about a 7-figure settlement." That got my attention. "What's the risk?" "The risk is they might have some document you're not aware of, something that could give them a legal leg to stand on. But from what you've shown me, I don't think that's likely. Your grandfather's lawyer was meticulous." "Let's do it," I decided. "I'll inform them officially that this is my property, keep a record of everything, and then let them proceed." That afternoon, I drafted a formal letter to the Pinewood Estates HOA board, stating clearly that I owned the lake and all surrounding property within the 100-foot buffer zone, that no lake access rights had ever been granted to the development, and that any construction on my property would be considered trespassing and would result in legal action. I sent it certified mail, return receipt requested, and kept copies of everything. 3 days later, I got my first visit from the HOA president. Her name was Brenda Hutchinson, and she was exactly what you'd expect from an HOA president in an upper-middle-class development. Mid-50s, perfectly highlighted blonde hair, designer athleisure wear, and an expression that suggested she'd never been told no in her entire life. She knocked on my door at 9 in the morning on a Saturday. I answered in my bathrobe, coffee in hand. "Are you Blake Jenkins?" she demanded without preamble. "That's me." "I'm Brenda Hutchinson, president of the Pinewood Estates Homeowners Association. We need to talk about your ridiculous letter." I took a sip of my coffee. "Would you like to come in?" "This won't take long. Your letter is full of inaccuracies and is interfering with a legally approved development project that will benefit the entire community." "My entire community is me," I said. "I live alone." Her eyes narrowed. "The Pinewood Estates community has 573 residents. Our community has every right to access the lake that borders our development." "The lake doesn't border your development. My property borders your development. The lake is in the middle of my property." "That's absurd. No one owns a lake." I almost laughed. "Plenty of people own lakes." "Brenda, I'm one of them. I have the deed to prove it. Our attorney has assured us that we have grandfathered access rights based on the original development agreement from 1996. "Then your attorney is wrong. I have every document from that sale. There are no lake access rights mentioned anywhere." Brenda's face was turning red. "We've already invested $30,000 in surveying and planning for this project. The dock company has been contracted. Materials have been ordered. You cannot simply stop this at the last minute with some spurious claim about property ownership." "I'm not stopping you," I said calmly. "I'm informing you that you're about to build on my property without permission. What you do with that information is up to you. We'll sue you for interference and damages. You're welcome to try. I'll see you in court, Brenda." She sputtered for another few minutes, threatened me with everything from legal action to social ostracism, and finally stormed off to her white Mercedes SUV. I watched her peel out of my driveway, spraying gravel, and went back to my coffee. 2 days later, I received a formal letter from the HOA's attorney, a guy named Mitchell Shaw from a mid-sized firm in Madison. The letter was full of legal language, but the gist was clear. They claimed they had implied access rights based on decades of residents using the lake for recreation. They claimed the original development agreement included water access even if not explicitly stated, and they claimed that my attempt to prevent development was in bad faith and potentially actionable. I forwarded it to Richard, who called me that evening. "This is weak," he said, "very weak. Implied access rights don't supersede deed ownership, and there's nothing in the development agreement that even hints at lake access. They're bluffing." "So they're going to build anyway?" "Looks like it. Shaw is probably advising them they have a case, which is borderline malpractice in my opinion, but not surprising. HOAs tend to be very aggressive, and they have a lot of money to throw around." "Good. Let them build." The construction started 2 weeks later. I watched from my porch as trucks rolled in, heavy equipment was unloaded, and crews began working on the shoreline. They were building high-end composite docks with electrical hookups, lighting, and boat lifts. Each dock was clearly designed for luxury boats with wide berths and professional-grade construction. I documented everything. I took photos daily, sometimes hourly. I kept a log of every truck that came in, every worker who showed up, every piece of equipment used. I noted the construction company's name, the dock manufacturer, everything. Richard had advised me to be thorough, and I was. Brenda showed up twice more during construction, once to threaten me with police action for harassment when she saw me taking photos, and once to serve me with a cease and desist letter demanding I stop stalking the construction site. I informed her that I was documenting activity on my own property and that she was the one trespassing. Both times ended with her speeding away in fury. The construction took 6 weeks. By the end of July, 40 beautiful luxury docks stretched along the shoreline of my lake, complete with power pedestals, water hookups, and decorative lighting. The HOA had clearly spared no expense. I estimated the total construction cost at somewhere north of $600,000. The day after construction was completed, the HOA threw a lake access celebration party. They sent invitations to all Pinewood Estates residents, but pointedly excluded me. I could hear the music and laughter drifting across the water as I sat on my porch that evening. People were walking down the new decorative pathway they'd built, admiring the docks, taking photos. Some residents had already brought boats and were securing them to their assigned slips. I waited one more week, letting them enjoy their new amenity. I wanted to make absolutely certain that the construction was complete and that residents had begun using the facilities. Then, on a Monday morning in early August, Richard and I filed suit in Pierce County Circuit Court. The lawsuit was comprehensive. We sued for trespass, conversion of property, unjust enrichment, and sought damages including the full cost of the dock construction, removal costs, compensation for loss of use of my property, and punitive damages. We attached every document I'd collected, my property deed, the original survey, all correspondence with the HOA, photos of the construction, and my detailed logs. We also filed for an immediate temporary restraining order preventing any further use of the docks pending resolution of the case. The HOA was served on a Tuesday. By Wednesday afternoon, Brenda was at my door again, this time accompanied by Mitchell Shaw, their attorney. "This is outrageous!" Brenda practically shrieked when I opened the door. "You waited until after we built everything to sue us? That's entrapment." "That's not what entrapment means," I said, "and I warned you multiple times that you were building on my property." Mitchell Shaw held up a hand to quiet Brenda. He was a slick-looking guy in his 40s, expensive suit, practiced smile. "Mr. Jenkins, I think there's been a significant misunderstanding here. Perhaps we can resolve this without litigation." "I'm listening." "The HOA would be willing to grant you honorary membership status, waive all fees, and even give you priority selection of dock space. In exchange, you could grant a permanent easement for the dock facilities." I shook my head. "No deal. You built on my property without permission after I explicitly told you not to. Why would I reward that behavior?" "Be reasonable," Shaw said, his smile tightening. "These docks benefit everyone. Removing them would be wasteful and expensive." "Should have thought of that before you built them." Brenda lost it. "You're just a bitter old man who can't stand seeing other people happy. You're sitting on this property like some feudal lord, while hard-working families just want to enjoy the lake." "I'm 38, I said, "and I'm sitting on my property, which I own, which you trespassed on. Now get off my porch before I call the sheriff." They left, but not before Brenda delivered a string of threats about countersuits, community action, and social media campaigns. True to her word, by that evening, there were posts all over Facebook about the greedy landowner trying to destroy community amenities and heartless neighbor suing hard-working families. Some residents were calling for boycotts of any business I might be associated with. Others were organizing protests. I didn't engage. Richard had advised me to maintain radio silence on social media and let the facts speak for themselves in court. The temporary restraining order hearing was set for the following Monday. Judge Patricia Morrison presided. She was a no-nonsense woman in her early 60s with a reputation for being fair but strict. Mitchell Shaw argued that the TRO would cause immediate and irreparable harm to his clients, that residents had made financial investments in boats and recreational equipment based on the dock availability, and that my claims of ownership were disputed and should be resolved at trial before any restrictions were imposed. Richard countered with my property deed, the original survey, and the certified letters I'd sent warning the HOA. "Your Honor, this isn't a disputed claim. The plaintiff has clear, documented ownership going back 70-plus years. The defendants were explicitly warned that they were building on private property and chose to proceed anyway. The harm here is to my client, who has had his property converted to someone else's use without compensation or permission." Judge Morrison reviewed the documents carefully. After 20 minutes, she looked up. "Mr. Shaw, do you have any documentation showing your clients have a legal right to build on this property?" "We believe the original development agreement from 1996 implicitly includes lake access rights, Your Honor." "Do you have the development agreement with you?" Shaw produced a thick document. The judge read through it, then looked up. "I see nothing in here about lake access. I see an easement for road and utility access, nothing more. The access has been implied through years of use, Your Honor. Residents have been using the lake recreationally since the development was built. Permissive use doesn't create ownership rights, counselor. You should know that. Judge Morrison's tone was sharp. I'm granting the temporary restraining order. No use of the docks pending resolution of this case. Trial is set for October 15th. Both parties will have adequate time to conduct discovery and prepare their arguments. The HOA's reaction was predictable. Social media exploded with outrage. Residents organized a protest at my property the following Saturday, with about 50 people showing up with signs saying things like, "Stop the lake bully," and "Community over greed." The Pierce County Sheriff's Department had to send deputies to make sure things didn't get out of hand. I watched from my porch as Brenda led chants through a megaphone. The deputies made sure protesters stayed on the public road and didn't enter my property. After about 2 hours, everyone got tired and went home. Discovery was where things got interesting. Richard subpoenaed all of the HOA's documents related to the dock project, including board meeting minutes, financial records, and correspondence with their attorney. What we found was damning. The board meeting minutes from January showed that Brenda had actually presented my grandfather's property survey during a planning session. Several board members had questioned whether they had the right to build on the lake. Brenda had dismissed these concerns, stating that no one is going to stop a project that benefits the entire community, and that we'll deal with any issues if and when they arise. Even worse, Mitchell Shaw had sent the board a memo in March after reviewing the development agreement, stating that the HOA's claim to lake access was questionable at best, and recommending they either negotiate with me directly or abandon the project. Brenda had responded to this memo by email, saying the board had voted to proceed anyway, and that Shaw should find a legal theory to justify the construction. In other words, they'd known all along that they were probably trespassing, and they'd done it anyway, gambling that I either wouldn't notice, wouldn't care, or wouldn't be able to afford to fight them. Richard was practically gleeful when he showed me these documents. This is willful, knowing trespass. We can absolutely get punitive damages now. We also subpoenaed the construction contracts and invoices. The total cost of the dock project was $740,000. The HOA had funded it through a special assessment charge to all residents. Plus, they'd taken out a loan for the balance. As the trial date approached, the HOA made several settlement offers. First, they offered to pay me $50,000 for a permanent easement. Richard rejected it immediately. Then they offered $100,000, then $250,000. We rejected every offer. "They're getting nervous," Richard said. "They know the documents we found are devastating." The trial started on October 15th. The Pierce County Courthouse was packed with Pinewood Estates residents, many wearing matching blue T-shirts that said, "Save our docks." Judge Morrison called for order and proceeded with opening statements. Richard laid out our case methodically: clear ownership, explicit warnings, knowing trespass, substantial damages. Mitchell Shaw tried to paint me as an unreasonable neighbor, trying to prevent community enjoyment of a shared resource. But even as he spoke, I could tell his heart wasn't in it. The documentary evidence was just too strong. The first witness was myself. I testified about the property history, my grandfather's careful preservation of the lake, the warnings I'd given the HOA, and the construction that had proceeded anyway despite those warnings. Shaw tried to make me look bad on cross-examination. "Mr. Jenkins, isn't it true that you've allowed residents to fish in the lake in the past?" "Yes, with my permission." "And you never charged them for that access?" "No." "So you've established a pattern of allowing community use of this lake, haven't you?" "I've allowed occasional recreational use with my permission. That's very different from allowing someone to build permanent structures." "But you admit the lake has been used by the community?" "The community has sometimes asked permission to use my property, and I've sometimes granted it. That doesn't give anyone the right to build on it." Shaw tried a few more angles, but none of them landed. The basic facts were too clear. Next, we called a surveyor who'd done an independent evaluation of the property. He testified that my deed and the original 1952 survey were clear and unambiguous. I owned the lake and a 100-foot buffer around it. The docks were all within my property boundaries. Then, we called a real estate appraiser who testified about damages. He stated that the construction had not only cost $740,000, but it also diminished the value of my property by restricting my own potential use of the shoreline. He estimated total damages, including removal costs, at approximately $1.2 million. The HOA's case was weak from the start. They called several residents who testified emotionally about how much they loved the new docks, how it had brought the community together, how their children enjoyed fishing there. It was sympathetic, but it was irrelevant. None of it addressed the fundamental question of whether they had the right to build there. Shaw tried to argue adverse possession, claiming that decades of residents using the lake had given them legal rights. Richard demolished this on cross-examination, pointing out that adverse possession in Wisconsin requires exclusive, hostile, open, and continuous use for 20 years, and that the occasional fishing trips didn't meet any of those criteria. They called a title insurance expert who tried to argue that the lake should have been considered a common area of the development, but he fell apart when Richard showed him the original plat maps and development agreement, which clearly showed my property as separate and distinct. The most dramatic moment came when Richard called Mitchell Shaw to the stand. As the HOA's attorney, Shaw had been advising them throughout the project, and his communications with the board were now evidence in the case. Mr. Shaw, did you send a memo to the HOA board in March of this year regarding the dock project? Yes. And in that memo, did you state that the HOA's claim to lake access was, quote, questionable at best? Shaw shifted uncomfortably. I expressed some concerns about the legal basis for the project. You did more than express concerns, didn't you? You specifically recommended that they either negotiate with Mr. Jenkins or abandon the project, correct? I provided my legal opinion, yes. And after you provided that opinion, Ms. Hutchinson sent you an email telling you to find a legal theory to justify the construction anyway, didn't she? The board felt strongly about moving forward. That wasn't my question. Did Ms. Hutchinson instruct you to find a legal justification for construction after you told her the HOA probably didn't have the right to build? Shaw looked at the judge, then back at Richard. Yes, there was murmuring throughout the courtroom. Judge Morrison banged her gavel for quiet. And did you find such a justification? I provided several theories that might support the HOA's position. But you never changed your opinion that the HOA probably didn't have the right to build on Mr. Jenkins's property, did you? I thought our legal position was arguable. Richard let that hang in the air for a moment. Arguable, but not strong. No case is certain until decided by a court. Mr. Shaw, in your March memo, you rated the HOA's chances of prevailing in a legal dispute over lake access at less than 30%, didn't you? Shaw hesitated. That was a preliminary assessment. Did you or did you not assess their chances at less than 30%? Yes. The damage was done. The HOA had known they probably didn't have the right to build, and they'd done it anyway. Brenda took the stand next, and she was a disaster. She was combative, dismissive, and refused to take responsibility for anything. When Richard asked her why she'd proceeded with construction after being warned by both me and her own attorney, she said, "Someone had to stand up for the community. We couldn't let one selfish person ruin things for everyone." So you knew it was Mr. Jenkins's property, and you built on it anyway? I knew he claimed it was his property. I didn't believe he had the right to stop us. Even though he had a deed showing ownership? Deeds can be wrong. Boundaries can be disputed. Did you have any evidence that his deed was wrong? I had my conviction that the lake should belong to the community. It was painful to watch. Richard didn't even need to push hard. Brenda was burying herself with every answer. The trial lasted 3 days. Closing arguments were on the afternoon of the third day. Richard summarized the evidence: clear ownership, explicit warnings, knowing trespass, substantial damages. He asked the judge to award the full $1.2 million in compensatory damages plus additional punitive damages to punish the willful nature of the trespass. Shaw did his best to argue that punitive damages were inappropriate, that the HOA had acted in good faith based on a reasonable belief in their rights, but even he seemed to know it was hopeless. Judge Morrison took the case under advisement and said she'd issue a written ruling within 2 weeks. The ruling came down on November 2nd. I was at my computer working when Richard called. "We won," he said simply. "Everything." He emailed me the decision. Judge Morrison had written a thorough 20-page opinion that methodically destroyed every argument the HOA had made. She found that I had clear, unambiguous ownership of the lake and surrounding property. She found that the HOA had committed willful trespass after being repeatedly warned. She found that the construction of the docks constituted conversion of property and unjust enrichment. For damages, she awarded the full construction cost of $740,000, plus $300,000 for removal and restoration of the property, plus $200,000 for loss of use. Total compensatory damages, $1.24 million. But she didn't stop there. Finding that the HOA had acted willfully and in bad faith, she awarded an additional $500,000 in punitive damages. She also ordered the HOA to pay all of my attorney's fees and costs, which came to about $150,000, total judgment nearly $2 million, and she ordered the HOA to remove all docks within 90 days or face additional penalties of $10,000 per day. The reaction from Pinewood Estates was immediate and explosive. Residents were furious, but now their anger was divided. Many were angry at me, but a growing number were angry at Brenda and the HOA board for creating this disaster. The HOA held an emergency meeting 3 days after the judgment. Over 200 residents attended. I heard about it afterward from a couple of residents who reached out to apologize for the way the situation had been handled. According to them, the meeting had been chaos. Residents demanded to know how the board could have been so reckless, how they could have spent $750,000 on a project they didn't have the legal right to build, how they were now facing a $2 million judgment that would bankrupt the HOA. Brenda had tried to maintain control, arguing that they should appeal the decision, but residents had shouted her down. Someone made a motion to remove the entire board and call for new elections. It passed overwhelmingly. The new interim board, led by a retired accountant named Gerald Foster, reached out to Richard within a week. They wanted to negotiate a settlement. Richard and I met with them in his conference room. Gerald was straightforward and apologetic. "Mr. Jenkins, the previous board created a disaster. We're looking at bankruptcy, massive special assessments on every homeowner, years of litigation if we appeal. We'd like to find a reasonable resolution if possible." "I'm listening," I said. "The judgment stands. We're not disputing it. But the removal and restoration costs are going to be expensive for us to handle properly. What if we offered you the full $1.24 million in compensatory damages plus your attorney's fees, and in exchange you agreed to waive the punitive damages and allow us to remove the docks at our own pace over the next year?" I looked at Richard. He shrugged. "It's your call." I thought about it. The punitive damages would be nice, but I wasn't trying to destroy the whole community. Most of the residents hadn't had any say in this disaster. They just trusted their HOA board to make good decisions. Throw in a permanent acknowledgement in the development's recorded covenants that I own the lake and all buffer property with no access rights for the development, and you have a deal. Gerald nodded immediately. "Done. We'll draw up the paperwork." The settlement was finalized 2 weeks later. The HOA paid me $1.39 million, plus they recorded a permanent declaration of my property rights in the County Register of Deeds. They had 1 year to remove all the docks and restore the shoreline to its natural state. But the story didn't end there. Several residents filed a lawsuit against Brenda Hutchinson, Mitchell Shaw, and the other former board members for breach of fiduciary duty and gross negligence. They argued that the board had recklessly wasted HOA funds and exposed the community to massive liability. That case settled out of court, but word got around that Brenda's homeowner's insurance had paid out a substantial sum and that she'd quietly put her house up for sale. She moved out of Pinewood Estates in February. Mitchell Shaw faced disciplinary proceedings with the Wisconsin State Bar for his handling of the case. The bar found that he'd provided substandard representation by allowing his client to proceed with construction despite his own assessment that they likely didn't have the legal right to do so. He received a public reprimand and had to complete additional ethics training. As for me, I got my lake back. The HOA crews spent the winter and spring carefully removing all 40 docks, the lighting systems, the decorative pathways, and all other improvements. By May, almost a year after the whole mess started, my shoreline looked much like it had before, maybe even better since they'd done a thorough restoration. The money was substantial, more than I'd expected. I used part of it to do some long overdue renovations on my grandfather's farmhouse. I also established a conservation easement on the lake property, ensuring it would remain undeveloped in perpetuity. And I donated a chunk to the Pierce County Land Trust to help preserve other natural areas in the region. The relationship with Pinewood Estates eventually normalized somewhat. The new HOA board was professional and respectful of property boundaries. A few residents even reached out to apologize personally for the way things had gone down. And I granted them permission to fish from the shore occasionally, just like before. I learned some valuable lessons from the whole experience. First, people will often ignore clear legal rights if they think they can get away with it, especially when they believe they're acting for some greater good. Second, documentation is everything. If I hadn't kept meticulous records and photos, if I hadn't sent those certified letters, the case might have been much more difficult. Third, sometimes the best strategy is patience. Letting them finish construction was risky, but it made the damages clear and undeniable, which ultimately led to a better outcome. Most importantly, I learned the value of what my grandfather had preserved. He'd understood that land, especially natural land with water, was precious and irreplaceable. He'd fought to keep it intact through multiple generations, and now I'd fought to keep it intact for future generations. The conservation easement would ensure that his vision would outlast all of us. On warm summer evenings, I still sit on my back porch and look out at the lake. It's quiet now, peaceful, just like my grandfather intended. The water reflects the sunset in rippling gold and orange. Occasionally, a heron stalks the shallows hunting for fish. The trees rustle in the breeze, and there's not a single dock in sight. The whole saga had been exhausting, frustrating, and at times infuriating. But standing on that porch, looking at that pristine lake, knowing it was protected, I had to admit it had been worth it. My grandfather had trusted me with this land, and I'd honored that trust. Sometimes people ask me if I regret how things went down, if I wish I'd just granted the easement and taken some token payment to let them keep the docks. The answer is always no. It wasn't about the money, though the judgment was certainly satisfying. It was about the principle that you don't get to take what isn't yours just because you want it, just because you think it would be nice, just because you've convinced yourself that your community's desires outweigh someone else's property rights. Brenda and the old board had gambled that I wouldn't fight or couldn't fight, or that their numbers and resources would overwhelm me. They'd been wrong on all counts, and their willful blindness to the law, their dismissal of their own attorney's warnings, their arrogant certainty that they'd get away with it, had cost their community nearly $2 million. I heard through the grapevine that the special assessments to cover the judgment had been steep, several $1,000s per household. Some residents had been forced to take out loans to pay their share. Property values in Pinewood Estates had taken a hit too, as the whole fiasco had been covered extensively in local media, and potential buyers were wary of the HOA's history of poor decision-making. The new board had worked hard to rebuild credibility. They had implemented new procedures requiring legal review of any major project. They had increased financial transparency, and they'd established clear protocols for respecting neighboring property rights. From what I could tell, they were doing a decent job of cleaning up the mess they'd inherited. As winter turned to spring and then summer again, life returned to normal. I worked on my software projects. I maintained the property. I enjoyed the peace and quiet that had drawn me here in the first place. The lake went through its seasonal changes, freezing solid in January, breaking up into scattered ice flows in March, finally clear and sparkling by May. One Saturday in June, about a year and a half after the whole thing started, I was doing some maintenance on my dock. Yes, I had a single small dock for my own use, properly located on my own property when a car pulled up my driveway. I walked up to see who it was. A young couple got out, both in their early 30s. The woman was pregnant. "Mr. Jenkins?" the man asked tentatively. "That's me." "I'm David. This is my wife, Hannah. We just bought a house in Pinewood Estates. We wanted to introduce ourselves and apologize for everything that happened." "You don't need to apologize," I said. "You weren't involved." We know, but still. We heard the whole story when we were looking at houses. It made us really wary of the development, but the new board seems solid, and we love the neighborhood. We just wanted you to know that not everyone there thinks you were wrong. What the old board did was completely out of line, Hannah spoke up. We also wanted to ask, and please feel free to say no, but we love fishing, and we heard you sometimes let people fish from the shore. Would it be okay if we came by occasionally? We'd always ask first and respect any boundaries you set. I smiled. Sure, that's fine. Just knock on the door first if I'm home, and don't leave any trash. Their faces lit up. Thank you so much. We really appreciate it. They left after a few more minutes of pleasant conversation, and I realized something. The fight had been worth it not just for protecting the property, but for establishing clear boundaries and expectations. The old HOA had operated under the assumption that they could do whatever they wanted and that everyone would just go along with it. Now, residents understood that property rights meant something, that boundaries existed for a reason, that asking permission was both necessary and appropriate. As I write this, sitting on my back porch on a warm evening in late June, watching the sun set over the lake that my grandfather preserved and I defended, I feel a deep sense of satisfaction. The legal battle had been stressful and time-consuming, but it had achieved exactly what it needed to achieve. The property was secure, my rights were firmly established, and a valuable precedent had been set about the limits of HOA authority. The money from the settlement sat in investments, growing steadily. I'd used what I needed for the house and the conservation easement, but most of it remained, a testament to the value of standing firm on principle, even when the odds seemed against you. Would I do it all again if faced with the same situation? Absolutely. Sometimes you have to fight for what's right, even when it would be easier to give in. Sometimes you have to trust that the law will work the way it's supposed to, even when powerful people are aligned against you. Sometimes you have to be patient and strategic, letting your opponents dig themselves deeper rather than acting impulsively. The lake stretches before me, calm and beautiful in the fading light. Somewhere across the water, in Pinewood Estates, families are having dinner, kids are playing, lives are being lived. And that's fine. We've found our equilibrium, them in their development and me on my preserved land, each respecting the other's space. My grandfather would have been proud. He'd fought his own battles to preserve this place, and now I'd fought mine. The land would continue, protected and pristine, long after all of us were gone. And that, ultimately, was what mattered most.